The chair recognizes the gentleman from Louisiana, Mr. Richmond, for 5 minutes.
Mr. General, I have the honor of serving as chair of the Congressional Black Caucus. You were not there, but I'm sure you are aware, and if you're not aware, I'm telling on myself, that I testified against your nomination. And I did so because I was afraid that we would go back to a time where discrimination was rampant and that diversity was not appreciated and that the right to vote for minorities and African Americans would be further, more obstacles would be set up. And I listened to your opening statement and I listened to your remarks since then, and you talked about voter ID. The VC case, which in Texas ruled that their Texas voter identification law had discriminatory portions against African Americans. The district court ruled that way, the appellate court affirmed that ruling, and then you withdrew from the case after two courts ruled that it was discriminatory. How does that mesh, and then argued on the side of Texas, how does that mesh with the right to make sure that African Americans had unfettered access to the voting polls?
Congressman, the way that happened was that Texas had passed a voter ID law that the courts did not approve but struck down. Election was coming up, I believe, and the court approved a voter ID procedure that they approved for that election, and the Texas legislature then repealed its previous law that had been found to be unconstitutional or improper and passed the one that the court had approved. So we felt that the voter ID law has been approved. A proper voter ID law is constitutional, and we believe that one is constitutional, and that's why the position was changed.
And also in judging Department of Justice, in terms of nominating judges to the bench, our information tells us that out of all the judges that have been nominated, I think 91% have been white males. Does that foster diversity?
I'm not aware of the numbers, but you should look for quality candidates, and I think diversity is a matter that has significance.
Well, the National Bar Association could recommend and has recommended a number of African American and other minority attorneys who are qualified. So let me just ask you, and if you don't know the answer to these, just let me know that you'll get me the information. But how many African Americans do you have on your senior staff?
I do not have a senior staff member at this time that's an African American.
Out of all
I would note in Alabama, I participated in recommending an African American judge, and I've had judges before. And
we're talking about this administration, though, of all of the U.S. attorneys that have been nominated or confirmed, how many have been African American?
One in Alabama that I've recommended that I knew.
And I believe he's
been confirmed.
I believe it's only that one. Out of all of the special agents in charge of FBI bureaus around the country, how many are African American?
I do not know.
Would you get that for me? And here's the gist of what I'm saying. For a lot of people who objectively look from the back, like I do and many people where I live, the question is whether we're going towards inclusion and diversity or whether we're going back. So I applaud the president for his approach to the opioid epidemic, which everyone in this room is concerned about. We're losing over 100 people a day. But your decision to reverse Eric Holder's Smart on Crime initiative goes back to the crack, tough on crime, and I think you specifically said that you want the U.S. attorneys to charge and pursue the most serious, readily provable offenses and sentences. But with opioids, we're treating it as a mental health crisis. And the question becomes, from the outside looking in, is it because of who the opioid crisis is affecting as opposed to crack? Our answer to crack cocaine was mandatory minimum sentences. So the question is, how does an outside observer reconcile how we treated crack, and which led to mass incarceration, which now with the epidemic we're losing thousands and thousands of people a year, and we're treating it with hugs and kisses and treatment, as opposed to tough on crime, lock them up. How do I reconcile that and not conclude that the only difference is race and income?
Well, I would say that the federal court focuses on serious offenders, not users. We talk about international drug cartels. We talk about distribution networks, serious gangs, MS-13. We focus aggressively on that. But the PSN, the new reinvigorated crime problem, focuses more, and I've been convinced of this, on the leading criminals in a neighborhood. And the federal government will not seek mass incarceration so much as we will be focusing on identifying the people who really are the driving force, maybe sucking other young people into crime that would never have been brought in there if they hadn't had this leadership drive. It's worked in New York, it's worked in other agencies, and I think it will work here. And Congressman, I would note that the average federal sentence in the last 3 or 4 years has dropped 19%, and the federal prison population is down 14%, while we are beginning to see a spike in homicides, the likes of which we hadn't seen since the 1960s.
Time of the gentleman has expired. The chair recognizes the gentleman from Texas, Mr. Farenthold, for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, thank you for being here. Before I got to Congress, I was a computer consultant, so I'm a little, I sometimes dive into the nerdier end of things. The incursion into the DNC servers is back in the news recently. My question is, can you tell us if anyone at the DOJ, FBI, or any other federal law enforcement agency has been able to take a look and forensically examine that server to determine who hacked it, whether it was the Russians, an inside job, or somebody else?
You said the
DNC.
DNC. I'm not able to comment on that. It's ongoing investigation. And
I appreciate that. We've also talked a little bit today about the FISA court and 702 and surveillance. And one of the things that I don't think has been completely answered is why does the DOJ think it's so problematic to require a warrant from the FISA court before access, or any court, before accessing or disseminating the contents of communications that aren't related to foreign intelligence that deal with American citizens?
well, the way, maybe I should explain this. When you have a warrant or you have a surveillance on a foreign individual that may be connected to terrorism or any foreign individual, you listen to who they talk to. And if they call an American and you have a terrorist on the phone in Syria, you want to know who that American is.
But the USA Liberty Act
That's,
includes exceptions for emergencies and for individuals who are reasonably believed to be engaged in international terrorism or furthering their goals.
Well, I'm not sure I understand it.
There's an exception for dealing with emergencies and people who believe to be terrorists. It's the whole.
All right. Well, let me just say this. So if we get a lawful intercept from a federal judge of a mafia person in New York, he's not likely to be talking to many people not in the United States. And we're listening to the conversations of the people he talks to, and they're American citizens. And if they talk about a crime, you can use that evidence against them, and you don't have to have a separate warrant to access it. We're talking about in the 702 I hope you'll think through with me now. So you lawfully obtain this information. You could do it by hand in the old days, but now the computers do much of the work for us. So you know the names of the people that may be involved in this activity, and you can access those records just like you could access bank records that you got.
If it came up in any other way, you would have had to have gotten a warrant to get that wiretap.
Well, the problem with the warrant is, let's say this. Let's say you have information from an airport that somebody wants to learn to fly a plane but does not want to learn how to land the plane. as we saw one time.
And you go to the court and get a warrant in a matter of hours.
That does not give probable cause to tap that person's phone.
All right, I've got a couple other questions.
Okay,
I
I'm sorry.
appreciate your answer on that. I do want to talk, in the last Congress, we passed and enacted into law the Stop Advertising Victims of Exploitation Act, or the SAVE Act. This legislation makes it a criminal offense to advertise for commercial sex acts. Has the DOJ used this provision to prosecute online sex traffickers or websites they use, and if not, why not?
I'm not sure about that, Congressman. I have to, maybe can get back to you on that.
I would appreciate that.
Thank you.
All right, I've got a couple more here. I want to hit it, but I'm going to kind of take a step back and look at the big picture. I'm a lawyer. I went to law school. I've always considered the Attorney General to be the people's attorney. And I feel like over the past few years, under previous Attorney Generals, that the Attorney General has been more the President's attorney rather than the people's attorney. Can you tell me what you are doing in office to restore the confidence in the American people, both in the office of the Attorney General and agencies like the FBI, which most people used to have a very high respect for, but I believe that level of respect and trust has dropped dramatically in recent times?
These are serious questions. I believe as you get to know the FBI Director, Chris Wray, the new director, you will find him to be a man of high intelligence, great integrity, great character, and great capability. Clearly one of the nation's great lawyers on private practice, but many years in the Department of Justice as a prosecutor working with FBI agents. That's one thing we've got. I can tell you I have great confidence in him. My deputy, 27 years of professional that I chose to be my primary deputy. My associate attorney general, likewise, is a woman of the highest character and academic excellence and experience in the department. We are setting a tone of professionalism every day in what we do. So I think that's something we need to do. There are some matters that do need to be completed. The Inspector General is doing investigations of some significance, as in my letter. I believe you received a copy involving the FBI and the allegations that are there. We intend to make sure that no agency of the government, not just the FBI, is not following the kind of disciplines and practices they should follow. So I guess I would say to you, watch what we do. We're not going to be driven by politics. We're going to try to do the right thing, and I believe that time will show that to be true.
I see my time has expired. Thank you, Mr. Chairman.
The chair recognizes the gentleman from New York, Mr. Jeffries, for 5 minutes.
Mr. Sessions, I have a copy of the transcript of your testimony before the Senate Judiciary Committee in October. You stated under oath, "I don't recall," in some form or fashion 29 times. Is that correct?
I have no idea.
I have a copy of the transcript of your testimony before the Senate Intelligence Committee in June. You stated under oath, "I don't recall," in some form or fashion approximately 36 times. Is that correct?
I don't know.
In your testimony today, you have stated, "I don't recall," at least 20 times. Is that fair to say?
I have no idea.
Now, on October 4th, 2016, during a TV interview with Lou Dobbs, you criticized Hillary Clinton for telling FBI investigators, "I can't remember," approximately 35 times. You also stated during that Lou Dobbs interview that the intentional failure to remember can constitute perjury. Mr. Attorney General, do you still believe that the intentional failure to remember can constitute a criminal act?
If it's an act to deceive, yes.
Okay. Now, you testified in January that you had no contact with Russian operatives during the Trump campaign. Earlier today, you testified that your story has, quote, "never changed." Is that correct? That was your testimony earlier today, that your story has never changed, correct?
I believe that's fair to say.
Okay,
We've added added things that I did not recall at the time.
Right.
So my statement at the time was my best recollection of the circumstances, and as things are brought up.
Claiming my time, I understand.
All right.
Sir, you now acknowledge meeting with Ambassador Kislyak during the Republican National Convention, correct?
I remember I made a speech. He came up to me afterwards. I was standing in front of the speaker program and did chat with him.
Okay,
Had
thank you.
an
And you also
encounter, not a meeting. It was just an encounter at that time.
Okay, and you also met with the ambassador in September of 2016 in your office, as you've acknowledged, correct?
He asked for an appointment. I had two senior staffers, both full colonels in the United States Army, retired in
Now, you
the meeting with me.
you testified in June before the Senate Intelligence Committee that you had not heard even a whisper about possible Russian involvement in the Trump campaign. Yet we understand that you attended this March 31st meeting where George Papadopoulos talked about potential communications with Russian operatives. But also, according to your third quarter 2016 FEC filing, you hosted a Trump campaign dinner meeting on June 30th, 2016 at the Capitol Hill Club, is that right?
That's correct, I
And your
believe.
Senate reelection campaign paid for that meeting, is that right?
I think that may be so.
Okay, and Carter Page and George Papadopoulos both attended that June 30th meeting, correct?
That has been reported.
And at that meeting, Carter Page told you that he was going to Moscow in a few days, is that right?
Yes.
Okay.
That's, and he,
thank you.
he said it was a brief meeting as he was walking out the door. I don't recall that conversation, but I'm not able to dispute it. And
Understood. Reclaiming my time, I've got limited time available.
that is not, does that establish a, some sort of improper contact
I think
with
you understand.
Russians?
I think you understand
He's
that.
not Russian either, you
You
know.
understand, sir, I get to ask the questions, you provide the answers in this capacity, you're no longer in the United States Senate. You voted in 1999 to remove Bill Clinton from office on charges of perjury, correct?
That is correct.
In connection,
Well, there were other charges. I voted
simple
for
question.
impeachment, yes.
Yes, understand. To remove him, actually, impeachment's in the House. In connection with that vote to remove President Clinton from office, you gave this speech on the Senate floor on February 29th, 1999, and in it, you acknowledged that while serving as U.S. Attorney, you once prosecuted a young police officer who lied in a deposition. And in that speech, you decided to prosecute that young police officer even though he corrected his testimony. Now, you testified under oath before the Senate Judiciary Committee in January. You subsequently corrected that testimony in a March 6 written submission and have been forced repeatedly to come back to the Senate and now the House to clarify. When explaining your vote on the Senate floor to remove Bill Clinton from office, you stated that you refused to hold a president accountable to a different standard than the young police officer who you prosecuted. Let me be clear. The Attorney General of the United States of America should not be held to a different standard than the young police officer whose life you ruined by prosecuting him for perjury. I yield back.
The gentleman may respond if he chooses to.
Mr. Jeffries, nobody, not you or anyone else should be prosecuted, not me, or accused of perjury for answering the question the way I did in this hearing. I've always tried to answer the questions fairly and accurately. But to ask, did you ever do something, do you ever meet with Russians and deal with the campaign? You're saying Mr. Carter Page, who left that meeting, according to the press reports, and I guess his deposition or interview has been reported as saying, I'm going to Russia. I made no response to him, didn't acknowledge it. And you're accusing me of lying about that? I say that's not fair, Mr. Jeffries. I would say that's not fair, colleagues. That's not on any indication that I in any way participated in anything wrong. And the same with Mr. Papadopoulos. He talked about it's reported in the paper that he said something about going to Russia and dealing with the Russians, and I pushed back and said you shouldn't do it. So I don't think it's right to accuse me of doing something wrong. I had no participation in any wrongdoing with regard to influencing this campaign improperly.
The chair recognizes the gentleman from Florida, Mr. DeSantis, for 5 minutes.
Well, thank you, Mr. Attorney General. You didn't do anything wrong in that testimony. This question was jarbled. That's just not giving you any benefit of the doubt at all to do what these guys are doing to you. So I hear what you're saying, and you didn't do anything wrong there. I do want to talk to you about your recusal from the Russian case. You cited 28 CFR 445.2, saying you were involved with the campaign that triggered recusal. However, that regulation only applies to criminal prosecutions or investigations. When you recused yourself under James Comey's admission, that was a counterintelligence investigation, not a criminal investigation. So why did you cite that regulation to recuse from a counterintelligence investigation when its only applicability is for a criminal investigation?
I'm not sure that was expressed to me when I was given advice about it in those terms, number one. Number two, it could likely be interpreted as both. And so I felt...
Comey, after you recused, he testified March 20th. He said, I'm authorized to say there's a counterintelligence investigation. He was telling the president, you're not under investigation. So that's what he said. So I think that may have been misapplied, but I understand what you're saying.
I did follow the advice I was given.
I know you did. You've talked about you can't confirm or deny investigations. I think that's a good policy. Why was Comey allowed to confirm that investigation in March 20th, which invited all kinds of irresponsible speculation? You were recused. Somebody in the department authorized him to do that. Why did they break with the policy?
This was this March 20th you're talking about? I'm not, I don't recall how that exactly occurred, but I do agree with you, Congressman, that Mr. Comey talked more than he should. And he had no power, right, or justification in announcing the conclusion of a criminal investigation. He was the investigator, not the
I agree. I don't want to, sorry to interrupt. I got limited time. I agree with you. Let me move on. Uranium One case. I know you've been asked about it. Can you say, forget about whether it's under investigation, in the past, did the FBI or DOJ inform either President Obama, Secretary Clinton, or any cabinet secretary that it had uncovered evidence that Rosatom's main U.S. executive, Vadim Mikirin, was engaged in bribery, kickbacks, and money laundering before the Obama administration approved the Uranium One sale in 2010?
Is that the Mikirin matter, yes, the matter that was prosecuted in Maryland?
2014, but there was an informant in 2009, 2010. The FBI had evidence of bribery, kickbacks, and money laundering. Was that information conveyed to any of the relative people on the CFIUS board? Clinton, other cabinet secretaries, or was it given to the president?
The way I understand that matter is that the case in which Mr. Mikirin was convicted was not connected to the CFIUS problem that occurred 2 to 3 years before. When the case came to the United States Attorney's Office, Mr. Rosenstein's office in Maryland, CFIUS had already been approved by 2 years or more.
There was an FBI informant starting in 2009.
I have not talked with him, but the Department of Justice, I understand, has approved him providing information to the Congress, and I understand it'll be set up in a few days, and you'll be able to hear from him direct.
I think you should too, because from everything I've been proffered, he has evidence of illegal conduct 2009 and 2010 before this deal was agreed to involving Uranium One. It was all connected, and so I think that that's something that we need to do. And let me move on. The leaking you mentioned, you can't confirm or deny the existence of the leaks. Michael Flynn, some of these other leaks used politically against the administration. So let me ask you this. Since the president was elected, has anybody been held accountable criminally or administratively for leaking information against the administration with a political motive?
Well, I think the individual in Georgia had a motive that's been charged, we have 27 ongoing investigations. Some of those involve leaks before President Trump took office and some after.
Final question, just yes
But
or no.
before that, there was only 3 per year, only 9. There's 3 times as many this year as in the entire 3 years before being investigated.
Final question, why can't you just tell us whether or not the FBI expended resources to give money to Christopher Steele? It's not about going into the investigation. We have oversight over your department. Were taxpayer dollars used to give to Christopher Steele, yes or no?
I'm not able to do that. I think for several reasons. It's an ongoing matter, and also it may well involve classified information.
Thank you, Mr. Attorney General.
The chair recognizes the gentleman from Rhode Island, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman, and I apologize in advance, Mr. Attorney General. I'm going to try to go through some questions quickly. Multiple trustworthy reports revealed last week that the Justice Department may require AT&T to sell CNN, among other assets, as a requirement for the approval of its proposed acquisition of Time Warner. Subsequently, more reports have surfaced that Rupert Murdoch, the chairman of 21st Century Fox and a confidant of President Trump, has twice contacted AT&T in an effort to buy CNN. This is, of course, very disturbing to those of us that are responsible for oversight of these issues. And my first question is, has any White House employee or official, including the president, contacted the Justice Department regarding the AT&T Time Warner transaction or any other transaction?
I'm not able to comment on conversations or communications the Department of Justice top people have with top people at the White House.
Well, Mr. Chairman, I'd ask the witness be directed to answer the question. You're invoking the Fifth Amendment or you're invoking executive privilege. You just can't decline to answer because it's uncomfortable. So I'd ask, Mr. Chairman, that the witness be directed to answer my question.
The witness can answer the question in the fashion that he has determined.
Well, reserving my right, Mr. Chairman, then I'll move on. Mr. Sessions, are you not going to answer the question? Whether any White House officials have attempted to interfere or speak to the Justice Department about this transaction?
According to longstanding Department of Justice policy, the Department of Justice does not reveal privileged conversations or
reclaiming my time then,
conversations
Mr.
between
Sessions.
the White House
I'm going to move on to a new area.
Justice.
The Foreign Agents Registration Act, you're familiar with it?
Right.
You think it's good policy?
I think it's a good law.
You enforce it, correct?
It has value, yes.
In addition to Paul Manafort and Michael Flynn, have any other Trump campaign advisors or senior administration officials lobbied for foreign governments without disclosing it under the Foreign Agent Registrations Act?
I'm not able to comment on that.
Why not?
Repeat the question. Perhaps I misunderstood it.
In addition to Paul Manafort and Michael Flynn, have any Trump campaign advisors or senior administration officials lobbied for foreign governments without disclosing it under the Foreign Agent Registration Act?
That would be a matter that should be directed to Mr. Mueller, I believe.
Moving to a new question. On October 6th, the Department of Justice, actually you, on the behalf of the Department of Justice, issued a 25-page memo to all federal agencies purporting to provide guidance on religious liberty protections under federal law. In the guidance, you indicate that an exemption or accommodation for religious organizations from anti-discrimination law might be required even where Congress has not expressly exempted religious organizations. You remember that, right?
Yes.
Okay. Would that mean, under your interpretation, that an employee of FEMA could refuse to provide disaster assistance to an unmarried couple who live together based on the employee's religious belief that men and women should not cohabitate before marriage?
I don't believe that it could be interpreted that way. It's just a policy document. We didn't try to write it.
I really like
well, I just, you have to answer.
This is a yes or no. Would the guidance you provided permit a HUD-funded shelter to refuse to house an unmarried pregnant woman based on the grant recipient's belief that sex outside of marriage is a sin? Yes or no?
Every matter, first, I don't think so, number one, under the guidance, but also the guidance does not repeal established laws that are in place, and it was written, that guidance was to clarify the established
Thank
principles
you,
of
Mr.
religious
Sessions. I have very limited
freedom.
time. I appreciate your answer.
Well,
Now,
thank you.
returning to the Papadopoulos issue. In your October 18th testimony, you purport to have forgotten this conversation about, by Mr. Papadopoulos about Russia that you put an end to. You said you weren't being dishonest, you weren't making a false statement, you simply forgot it. Remember that testimony?
Something like that,
Okay.
yes.
When did you remember the remarks of Mr. Papadopoulos? When did that memory come back to you?
I think it was when the press came up with it, or it was revealed in the press.
That was the first time you remembered it.
I would recall that my October statements was a broad question.
No, I understand, Mr.
And
Sessions, I
that
have a
it,
limited time, reclaiming
this
my
event
time. You
occurred
were a
over-
senior, Mr. Sessions, you were a
It was
senior
over 18
campaign
months
official
before.
and a member of the national security team. Did you ever exchange any email, text message, or any other communication to or from Mr. Papadopoulos about Russia or any other subject?
Repeat the category list of things.
Exchange any email, text message, or any communication to or from Mr. Papadopoulos about any subject?
I do not believe so. I'm confident. I did not.
Did anybody ever forward to you a communication from Mr. Papadopoulos?
I don't recall it.
Did anybody from the campaign ever communicate with you about Mr. Papadopoulos?
I can't say that there were no conversations about him before or after this event.
Were you told
I
about the
did
content?
push back at him.
Time of
I
the
think.
gentleman has expired. The witness can answer the question. Chair.
I don't have a specific recollection, Mr. Chairman.
Mr. Chairman, I'd ask to make a unanimous consent request. I would ask unanimous consent to insert the following materials into the record. A letter from me and Ranking Member Conyers requesting a hearing on the President's interference with antitrust enforcement matters before the Justice Department. A letter from Senators Amy Klobuchar, Dianne Feinstein, and several others to the Justice Department urging it to oppose any attempt by the White House to interfere with antitrust laws, enforcement decisions, particularly for political reasons. A July article in the New York Times reporting that senior White House advisors have discussed using the AT&T-Time Warner merger as a potential point of leverage over CNN, and 9 letters from as far back as February of this year from various members of the Judiciary Committee seeking information on a wide range of subjects addressed to the Attorney General of the United States that have been ignored, that we have received no response from. I ask those.
Without objection, the document made part of the record. The chair recognizes the gentleman from Texas, Mr. Ratcliffe, for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, good to see you. If FBI Director Chris Wray held a press conference tomorrow without your knowledge to announce a charging decision in a major federal investigation, would you consider that an inappropriate departure from longstanding Department of Justice and FBI policy?
Under the situation today, under the letter that Deputy Attorney General Rosenstein wrote with regard to Mr. Comey, I think it would be a terminatable offense.
And to your,
That's not discipline. We need to be disciplined in this department. We don't need to be leaking, and we don't need to have people taking actions outside their realm. Maybe sometimes people make an honest mistake, but that would be a very dramatic thing, which he would never do.
so I'll take that as an emphatic yes. Now, to your knowledge, are there currently federal prosecutors in your office that are predetermining cases prior to the interviewing of key witnesses to include the subjects or targets of those investigations?
I don't believe so.
Is it a practice in your Department of Justice to allow immunized witnesses to sit in the interviews of the subject or target of federal investigations?
That would not be a normal process, for sure.
Mr. Attorney General, these are just a few of the irregularities or anomalies that have taken place in how the Department of Justice and the FBI have handled these investigations and prosecutions prior to 2016, and now apparently a departure from how you're handling them. It's also these irregularities that have shaken the faith and trust of people in our Department of Justice. Look, I'm of the opinion that for the last 8 years, we have survived the worst presidency of my lifetime. My colleagues on the other side of the aisle have spent their time today trying to convince you that we have to survive a bad president right now. That's okay. For 240 years, our republic has withstood that. Elected officials come and go. But right now, where we are, and what our history won't tell us, is what happens to our republic if people lose all faith and trust in the Department of Justice and the FBI to fairly investigate and to prosecute violations of the rule of law. Now, at one point in time, you and I held the same position in the Department of Justice. I was U.S. Attorney, as were you. You've obviously been promoted. If public opinion polls tell us anything, the chair that I hold right now signals that I've been demoted. But my time as U.S. Attorney taught me something that you said in your opening, which is that the Department of Justice must always transcend politics to uphold the rule of law. I think more than anything else, what the American people want to hear from you today is that that is in fact the case. As Mr. Gowdy said in his line of questioning, Lady Justice is supposed to be holding a set of scales, wearing a blindfold. She's not supposed to have her finger on the scales. And I think that the American people have every reason to question whether or not that's where we are right now. So more than anything else, what I'm asking from you is to hear from you that you are prepared, that you are committed to go wherever the facts and evidence lead you, regardless of the political consequences for any political party or any person, to include Donald Trump or Hillary Clinton or yourself.
Yes, I am, and the Department of Justice is. You will soon have Director Wray, I believe, coming before your committee. I hope you'll ask him these questions, and I think you'll be impressed with his commitment in that regard. As United States attorneys, it was we were raised in that idea. I've never forgotten. I'm glad I had my 15 years in the Department of Justice before I came to Congress. You get your values shaped maybe at a younger age, but I think I understand the role I have, the responsibility we have to do justice. And I would say this, that in the long run, if I want the respect of this body, both sides of the aisle, I've got to follow the rules in the department. And it may frustrate you that I can't answer questions or confirm you or other members on this side. It may frustrate people on this side. But if I'm not prepared to do that, then I don't think I'll ever restore the Department of Justice. And that's what our goal would be, to hopefully it's not as bad as you say, but I think there's danger out there, and we want to fix it.
Mr. Attorney General, thank you for your continued service. I yield back.
The chair would advise members of the committee that there are about 8.5 minutes remaining in this vote. The gentleman from California has persuaded me that will permit him to proceed, but other members are advised we will reconvene immediately following this vote series. And the gentleman from California, Mr. Swalwell, is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you for appearing, Mr. Attorney General, and please express my gratitude to the men and women who serve the Department of Justice. You stated in your opening statement that my story has never changed, but Mr. Attorney General, it has changed 3 times, and today we heard the 3rd edition when you told us that you do now recall Mr. Papadopoulos mentioning that he had contacts in Russia. And so I have a slide for you that I'd like to display. It's a January 10th, 2017 exchange with Senator Franken, where he asks about campaign communications with Russia. And you stated, Senator Franken, I'm not aware of any of these activities. Mr. Attorney General, if you were asked that question today, recalling that you are now aware of what Mr. Papadopoulos said on March 31st, would you answer that question differently?
All I would say to you, Congressman, is if you fairly treat the exchange I had with Senator Franken, I think you can understand where when I answered the question, I felt like I was answering it properly.
But you would agree today it should be answered differently if it was asked in the same form today, considering your recollection that you just gave us?
I believe that when you're asking me today, explicitly, did you meet with any other Russians?
Today,
I am prepared to say I did. I met with the ambassador in my office with at least 2 of my staff, senior respected patriots, colonels retired in the Army,
and Mr. Attorney
nothing
General,
improper occurred at all.
Once and for all, can we answer the
I
question.
am once and for all answering the question, Congressman. I don't understand why you won't take my answer.
Well, we're on the third edition, Mr. Attorney General. So during your time on the campaign, did any person on earth state that they were communicating with Russians, traveling to Russia, or asked the campaign to meet with Russians, to your recollection?
Was I asked that question?
No, I'm asking you today, to your knowledge, did any person on the campaign tell you they were going to Russia?
I'm prepared to answer the question, but I just will not answer it in a way that suggests that I in any way intentionally misled anyone when I answered the question.
What's the answer to the question, Mr. Attorney General?
The answer is I met with the ambassador in my office for less than an hour, I believe, and he came up to me after a speech at the convention when it was raised to me that this months later. Nobody said immediately it was an error. By press, I immediately revealed and acknowledged or told them the meetings I'd had.
With respect to Carter Page, he told you, as you just acknowledged, that he was going to Russia. He was also on the national security team, and this is the second person within about 3 months now that is bringing up Russian contacts, and you did not tell him to not go to Russia. Is that correct?
No, I didn't tell him not to go to Russia.
And you didn't tell anyone else on the campaign that he had told you that? Is
I
that
don't
right?
recall him saying that, but am I supposed to stop him from taking a trip?
Well, at that point, did you think that now that two people have talked about either going to Russia or having contacts with Russia, that the campaign where you were the chairman of the national security team might have a Russia problem?
Well, if I read what's been said about the Papadopoulos meeting, the one that was somewhat earlier than that, I did say you don't represent something to that. I pushed back at his trip and was concerned that he not go off somewhere pretending to represent the Trump campaign. He had no authority for that. This young man didn't have any ability and ought not to be going off representing the campaign.
Mr. Attorney General,
the next one is Carter Page, and he says, from what I see in his testimony, interviews, he said after the meeting was over, he goes out and
moving on, Mr. Attorney General.
he goes out and he says he's going to Russia. I made no response.
CIA Director Pompeo has called
So
WikiLeaks.
what does that mean?
Well, the
I
American
don't
people
think it
will
means
judge
that
that.
I've done anything dishonest.
Mr.
certainly
Attorney
doesn't-
General, the CIA Director has judged that WikiLeaks is a hostile, non-state intelligence service. Do you agree?
I'm not able to disagree with that.
But candidate Trump, who you were working
He's
for,
more aware of its activities perhaps than I.
But candidate Trump said throughout the campaign, "I love WikiLeaks." Do you love WikiLeaks, Mr. Attorney General?
I'm not a fan of WikiLeaks.
Do you think it was appropriate that Donald Trump Jr. communicated with WikiLeaks during the course of the campaign?
I'm not able to make a judgment about that.
Thank you again for
Time,
appearing.
gentlemen, has expired. The committee will stand in recess until immediately after this vote.